Hello and welcome to 2023. Today is January 1st of 2023. And just like every other year, California has introduced a series of new employment laws that I will briefly discuss today. The first new law I'd like to discuss is bereavement leave. Bereavement leave was not a requirement for employers prior to 2023. This year, California employers with 5 or more employees must provide 5 days of bereavement leave upon the death of a family member of an employee. Now, these family members include a parent, child, sibling, grandparent, grandchild, domestic partner, and parent-in-law. The leave doesn't need to be taken consecutively, but it needs to be taken within 3 months of the family member's death. The leave is unpaid. On the other hand, an employee can choose to take vacation, sick leave, or other paid entitlement that the employee has. An employer may require that the employee provide documentation as proof for the need for bereavement leave. This includes a death certificate, crematorium documentation, funeral documentation, or any other written proof that the family member has died. Now, the documentation and the request for leave needs to be maintained as confidential by the employer. The next law I'd like to discuss is the California Family Rights Act, or the CFRA. The California Family Rights Act provides job-protected leave for eligible employees under certain circumstances. One of those circumstances is to care for a family member if they have a serious health condition. Now, under the new law, the term family member has been expanded. The term family member now includes designated persons. A designated person is one person that has been designated by an employee, and they must be a blood relative, or they must be the equivalent of a family member to the employee. The next law I'd like to discuss is paid sick leave. Paid sick leave provides for entitlements to employees to take about 24 hours per year to care for themselves or a family member. Pursuant to the new law, the term family member has been expanded. Like the CFRA, the term family member includes designated persons. The next new law I'd like to discuss is pay scale information. Prior to 2023, employers were not required to provide pay scale information to employees. Now, an employee can request pay scale information from their employer related to the position that they hold. Pay scale information includes a salary or hourly wages that the employer reasonably expects to pay employees for that position. In order to receive pay scale information, the employee needs to make a reasonable request in writing to the employer or some other designated person. The law also requires employers that have 15 or more employees to provide pay scale information to applicants or in job postings. And so any job posting, whether from the employer or from a third party that the employer is using to post a job, the pay scale information needs to be provided to such potential employee. The law also requires that the employer maintain the wage rate and job title as a history in a report because the Labor Commission can request such information. The next new law I want to discuss is an expansion to the Fair Employment and Housing Act, or FEHA. Before I discuss the expansion, I wanted to state that the Department of Fair Employment and Housing, the government agency that handles these types of claims, has been renamed. They are called the Civil Rights Department now. The expansion to FEHA is essentially a new protected characteristic. It also can be deemed an add-on to an existing characteristic. It is to the reproductive health decision-making of an employee. Now an employer is prohibited from discriminating against an employee for their reproductive health decision-making. Furthermore, an employer is prohibited from requesting the disclosure as a condition of employment the reproductive health decision-making of an applicant or current employee. The next new law I'd like to discuss is the Emergency Conditions Law. This new law prohibits employers from taking or threatening to take adverse employment action against employees who have a reasonable belief that there exists an emergency condition at the worksite or workplace. The law also prohibits employers from preventing employees from accessing a communication device and contacting emergency services or trying to assess the safety of the situation or to see if everybody's okay. The law requires that the employee must notify the employer of the reason for not showing to work or for leaving work early. Now, please note that the law does not protect employees if the emergency condition has ceased. Also, as specifically stated in the statute, health pandemic is not an emergency condition. The last new law I'd like to share with you is the expansion of the Cal Saver laws. Prior to 2023, eligible employers were required to offer a payroll deposit retirement savings arrangement to eligible employees so that they could contribute a part of their wages or salary to the program. With exceptions, the new law requires persons or entities with one or more employees to offer the program. And thank you for listening today. If you have any more information regarding Cal Savers or any of the other laws, please let me know or contact an attorney. And if you like this video, please subscribe. Have a great new year. Thank you.